Good morning, everyone. As Anne-Marie mentioned, my name is Joanna Cunningham and I am an Associate Solicitor in the Corporate and Commercial Department in Arthur Cox, Belfast. Thank you very much for joining me for this webinar on preparing your data for EU exit. I know 2020 hasn't turned out to be the year that any of us expected, and businesses have really had to grapple with the unprecedented challenges brought by COVID-19. And as a result of this, EU exit preparations have been forced to take a back seat. Although COVID-19 has stalled many things, EU exit is not one, and the end of the transition period is fast approaching, bringing with it implications for Northern Irish organisations, particularly in respect of data transfers with the EU. Therefore, the purpose of this webinar is to explain the position for organisations in Northern Ireland in relation to EU exit and specifically data transfers, and to remove any ambiguity about what organisations need to be doing to ensure that they are compliant with data protection requirements, both during and particularly at the end of the transition period on the 31st of December of this year. So the agenda for this morning is to give you a quick recap on the current data protection landscape and an overview of the changes following the end of the current transition period. I'm then going to take you through the impact of the EU exit on different data transfers, and this will probably be the main section of the webinar this morning. I will then go through key steps that organisations can take now to ensure that they remain compliant following the end of the transition period. And as Anne-Marie mentioned, I'm also going to be answering some questions at the end. So if there is anything you want clarified, please just submit your questions throughout the webinar and I will do my best to get to these at the end. So without further ado, I'm going to move on and give you a quick recap on the current data protection landscape. As you will all be aware, the EU General Data Protection Regulation and the Data Protection Act 2018 came into force on the 25th of May 2018, and both of these pieces of legislation must be read together. The GDPR is EU-derived legislation, whereas the Data Protection Act is UK-specific domestic legislation. The GDPR aims to ensure that personal data is afforded proper protection and that organisations are transparent with regard to how they process or use or transfer personal data. It's worth pointing out at this point that personal data is very widely defined under Article 4 of the GDPR and encompasses any information that could enable a data subject to be directly or indirectly identified. This means that it would be very unlikely that an organisation is not transferring some degree of personal data. And it is actually estimated that around 3/4 of the UK's cross-border data flows are with the EU. So this is particularly pertinent for Northern Irish organisations operating in the north and potentially also the south, because there's going to be implications for this after the end of the transition period, because Northern Ireland is obviously going to no longer be part of the EU, whereas the Republic of Ireland will. Turning quickly to the Data Protection Act 2018, this was introduced at the same time as the GDPR, and the intention of the Data Protection Act is to supplement GDPR standards into UK domestic law. The Data Protection Act 2018 also covers processing in specific contexts, so for example in relation to law enforcement and intelligence services. The Data Protection Act 2018 was introduced to ensure that the UK has an equivalent level of data protection to the EU member states. And this is something that's actually going to be very important for UK and EU negotiations on an adequacy decision. And an adequacy decision is something that I will be discussing in more detail shortly. Turning specifically to data transfers, under the GDPR, data transfers between various member states can take place freely. And this is because the EU Commission deems each member state to afford an equivalent level of data protection. This means that the position for data transfers across EU member states is very straightforward and data can flow in a streamlined manner. Before I start going through the different data transfers, I just thought I would put up some key dates to note on the screen, because you're going to be hearing some of these terms frequently throughout this presentation. So the most important one to note at present is that the transition period, being the period that we are currently in, is set to end on the 31st of December 2020. And this is going to bring with it implications for some of the different data flows to and from the UK. Turning firstly to look at transferring personal data during the transition period. So as you will all be aware, the UK officially left the EU on the 31st of January 2020, known as Exit Day. But the withdrawal agreement provided for a transition period spanning from exit day up to the 31st of December 2020. And as I've just mentioned, this is the period that we are currently in. And during this period, the UK continues to be treated for most purposes as if it is still an EU member state. So in relation to data transfers, this means that during the transition period, EU law, including the GDPR, continues to apply to the UK, and data can continue to flow freely between the UK and the EU. So in a nutshell, during the transition period, there's no further action required for data transfers. It also means that organisations offering goods or services to people in the EU do not need to appoint a representative at this time. This is a concept that many organisations are not overly au fait with, and it's something I'm going to talk about later on, because at the end of the transition period, it's possible that a lot of organisations may need to consider appointing an EU representative. The expiry of the transition period on the 31st of December 2020 is really the time when things are going to become more complicated for data transfers, and this is just because we're no longer going to be bound by EU legislation. So what is actually going to happen after the transition period? Well, we know for certain that new legislation is going to come into force. The EU GDPR is going to be incorporated into the UK's domestic law as the rather aptly named UK GDPR, and this is going to be done via the European Union Withdrawal Act 2018. So the UK is also going to make certain related changes to the Data Protection Act 2018, just really to reflect the fact that the UK GDPR is going to be the new law rather than the EU GDPR. The ICO has also stated that following the EU exit, data compliance should continue as usual, with the key principles and obligations remaining the same. So this means that organisations that are currently GDPR compliant will remain so, because the provisions of the EU GDPR will be mirrored within UK law. The main area of uncertainty at the end of the transition period is whether the UK is going to have received an adequacy decision or not. And the timing of any adequacy decision is paramount, because this is going to have implications for different data transfers from the EU. What actually is an adequacy decision? Well, an adequacy decision is essentially the EU Commission's formal recognition that the UK has an equivalent level of data protection to that of EU member states. And in reality, this means that data transfers could continue between the UK and the EU without any further action needing to be taken. It is hoped that the UK GDPR is going to help demonstrate to the EU Commission that the UK will have an equivalent level of data protection in place, and therefore assist in securing an adequacy decision for the UK. As you will see from the slide, back in July, it was certainly hoped that we would have been granted an adequacy decision by the end of the transition period, but this now looks set to be unlikely. And this is perhaps due to the recent ruling of the Court of Justice of the European Union in a case called Schrems II. And this is a very important data decision that I'm going to be speaking about in more detail shortly, as it has consequences for some specific data flows. So if we don't have an adequacy decision, things are going to become a little bit more complex. The UK is going to become a third country for the purposes of the EU GDPR, and this means that data transfers from the EU to the UK are going to be restricted. So in other words, this means that personal data transfers to the UK are going to fall outside the protection of the EU GDPR, and they will no longer be able to continue freely. The These transfers must comply with the conditions set out under Chapter 5 of the EU GDPR. And as you will see from the slide, the relevant provisions of Chapter 5 are Article 46, the appropriate safeguards, and Article 49, the derogations. So just to clarify, even though the UK will mirror the EU GDPR via the UK GDPR, the UK is still going to be viewed as a third country for the purposes of the EU GDPR, which is why if we do not receive an adequacy decision by the end of the transition period, an additional transfer mechanism under Article 46 or a derogation under Article 49 will need to be put in place. So the next slide really is just a summary of what I have discussed, and I thought the diagram just might make it a little bit more straightforward for you to grasp all that I have just mentioned. So from the 1st of January 2021, there really are two outcomes. Either we have received an adequacy finding from the EU Commission and data transfers continue as normal, or else we become a third country and EU to UK data transfers are restricted and an appropriate safeguard or a derogation will need to be put in place.